Thank you so much, Ms. Butler, for coming to our studio, and thank you much for agreeing to speak to us.
Oh, no, thank you. It's my pleasure.
Recently, there was the Department of Justice released a press release and statement about the settlement of the case related to one of the former government officials in Armenia, Gagik Khachatryan, who used to be Minister of Finance and Tax and Custom Administration Chief. The case was related to his mansion or his family's. The mansion was owned by his family for cost around 63 million. At least it was on the market for this price. And the department, the case took around 2 years, if I'm not mistaken, maybe more, just to reach the settlement. Can you provide more details on the specific of this case involving the Khachatryan's family, and what was the main trigger for starting the investigation?
Yes, I'd be happy to talk about the public record facts in the case. First, I want to highlight that this was an action brought by the Department of Justice's Kleptocracy Asset Recovery Initiative, which is established in the criminal division in the money laundering and asset recovery section. And I emphasize this because I'm hoping that listeners will recognize who we are and will come forward with information about other matters that are of concern to them. So we were established in approximately 2010 in a formal way, and we have so far recovered about $1.7 billion, and we have returned and assisted in returning about $1.6 billion. So we are aggressively trying to meet the department's mission to recover assets linked to foreign corruption, and also to meet our UN Convention Against Corruption obligations. And to do that, we have a dedicated unit of prosecutors working with special FBI agents and other law enforcement agents. And this case is another success for us, and when we hope will benefit the people of Armenia. The case was filed in 2020, but on July 2022, in July of 2024, we announced, with the judge's approval, a resolution of the civil non-conviction-based forfeiture case against the asset. So in our work, we can use criminal prosecution and criminal forfeiture tools, but we also use civil non-conviction-based forfeiture tools. And in these cases, the asset is the defendant that we allege is involved in some criminal activity. And then we give the whole world notice of the action, and people who think that they have a right protected by our law can come in and argue with us, litigate with us, about whether our claims that the property was involved in a crime are proven. And so we filed this civil action against this property in Holmby Hills, California. It's a very exclusive neighborhood. It's currently on the market for around $39 million. We'd be very happy if it sold for more. The essence of the resolution is that the government will retain 85% of the sale price of the property. The claimants, who are the Khachatryan brothers, will receive the balance, the 15% of the recovered amount. But consistent with our obligations in our program, we will be recommending to our Attorney General that the net recovered proceeds be returned to the benefit of the people of Armenia through an agreement with the government to ensure transparent and accountable use of the funds.
So we are talking about 85%.
Yes.
That's, according to your recommendation, should be transferred to the Republic of Armenia, to the people of Armenia.
85% of the net recovered costs, because there will be some costs associated with the sale. There'll probably be some taxes to be paid, some sales-related expenses. But usually those are relatively small compared to the value of an asset like this. So there'll be lots to talk about with Armenian government and civil society about potential uses of this money, and we hope that we will be able to come to an agreement to use it to try to address any issues involving prosecution service or law enforcement or other priorities of the government to try to help ensure the continued success of the Armenian government in trying to tackle its corruption and money laundering issues.
And when the case started 2 years ago, or even more, what was the main trigger to start this investigation? And I'm sure you are there are a lot of probably classified information around this case because we're talking about big money. So during the investigation, what kind of key findings Department of Justice could find?
Yeah, so maybe the easiest way to explain that is that we are in constant communication with law enforcement partners, like in Armenia, where we hope to build successful confiscation cases. And so through that exchange, we learned that they were investigating the Khachatrans and their father. And so we exchanged information. They gave us information, records, the opportunity to interview witnesses in Armenia. We provided information that they said was important for their investigation. We did this through the formal mutual legal assistance process managed by our central authority and Armenia's central authority, but we also did this informally, FBI to the Armenian authorities. And so it was a combined, I won't say whole of government, but many offices in both governments contributed to the success. You asked about the specific allegations of the complaint. So the complaint is a public document, is available for anyone to read. We allege that at a certain point in time, a businessman, Cedric Armistanian, gave money to the Khachatryan brothers while their father was a senior public official in the form of what we characterize as sham loans. We say that these were not real loans, even though they were called loans, because they were never repaid, either in principal or in interest, over a long period of time. The money was invested in a circuitous way into this property, which is in Holmby Hills. The Khachatrans also invested additional money into this to redevelop it into the amazing property that it is now.
So this 15%, that's the money which was invested by Khachatryan family to make improvements, or this is how it was decided, 85 and 15%?
So it doesn't directly correspond to their investment in the property. It's a function of an evaluation, a negotiation about what we believed was the time and effort that would take to conclude this case, potential issues where we felt a judge might or might not, or a jury might or might not agree with us, so we call that litigation risk. So it's a reflection of many factors. And of course, the Khachatrans were pushing to get that number as low as possible as we pushed back. And it's not uncommon in civil confiscation cases to negotiate a resolution and to take into account the resources that would be needed in order to continue the fight. In taking that into consideration, the fact that it's in our interest to recover a tremendous sum and make it available to the government of Armenia for the people. So we balance all those factors in trying to negotiate these resolutions.
How do you assess the level of cooperation with Armenian law enforcement agencies, and who was your main counterparts during this investigation, if it's possible to discuss?
I think so certainly the Central Authority of Armenia and the Prosecutor General's Office, and there were various investigative agencies who provided information or who were available to help us to understand Armenian criminal process so we could understand the phase in which cases were moving in Armenia. So it's hard to say exactly. It was many offices of the government in Armenia, and obviously on the U.S. side, our Central Authority, our partners in the U.S. Attorney's Office in Los Angeles, so a field office of the Department of Justice, which has a fair amount of independence and its own staff, plus an FBI squad out in Los Angeles, and our central authority, I think likely our FIU also played a role in the U.S.
We are dealing with many specific cases related to the post-Soviet countries. Could you detail a little bit, or could you disclose some cases, if it's possible, if they are public, of course, some cases related to the post-Soviet areas, similar to the Khachatryan cases that your agency is following?
I can talk about some of them, but maybe I should explain that for us to be involved in a civil confiscation or a criminal investigation, we have to have some conduct in the United States or some transaction that affects the U.S. economy. So we often, as you do, read about lots of allegations against people in various countries in the world, including the former Soviet Republic, former Soviet Union, but we aren't in a position to act because we don't have U.S. jurisdiction under our laws. But
and who is providing this jurisdiction?
well, our courts decide what the meaning of our statutes are, but Congress passes our statutes. For example, we have a money laundering law which says that you must prove a predicate crime linked to the asset that you intend to try to recover, and that predicate crime could be a violation of foreign law. So our reach, although we need a transaction that affects the United States, so within U.S. financial institutions or through our correspondent banking system, we need a transaction, but the criminal conduct we can link it to is actually quite broad, because we can consider, for example, violations of Armenian bribery law, misappropriation law, fraud by or against Armenian banks. So we have the possibility to reach pretty far. In terms of other pending cases, we have had a long-running case involving the former Prime Minister of Ukraine, Pavlo Lazarenko. He was convicted in our courts in the Northern District of California in San Francisco many years ago. He served almost a 6-year prison sentence. But what we saw was that the scope of the charges in that case were narrower than allowed them to reach hundreds of millions of dollars, which there was U.S. jurisdiction to cover. So the criminal charges were narrower. We thought that we could use our civil confiscation tool to forfeit additional funds, and so we did. And we have been involved in a long-range civil litigation case with Pavlo Lazarenko to try to recover funds for Ukraine. We have.
Is the case over, or is it still ongoing?
It's still pending, but I'm happy to report that today we got another ruling that brings us closer to the possibility that we get the final order of forfeiture, and then Mr. Lazarenko can appeal if he likes, but we are moving forward even today. And that could be $260 million, $230 million. So lots of money, lots of sensitive issues. Sometimes these take a long time. So our ability to resolve this matter involving the Khachatrans relatively efficiently for a pretty significant amount of money, we think is the right balance for this case.
After the Russian invasion to Ukraine, there were a lot of sanctions against Russia, including in the banking sector. And I'm sure you were dealing also with some cases related to the money laundering, cases related to Russia. Do you have any details? Could you elaborate on this topic?
So we are contributing to the task force Klepto Capture, which is something that is a multi-office initiative overseen by the Deputy Attorney General's office. But because of the expertise that we have in non-conviction-based confiscation and money laundering, we're playing a significant role in the MLARs. And we have filed cases that you may be familiar with, and we can certainly provide you more. But for example, we've charged a number of people involved in the metals industry. And they have been charged, convicted, and sentenced in the Middle District of Florida in Tampa. They operated with a Ukrainian sanctioned person. And this person's name is Kurchenko. And he was actually sanctioned before the Russian aggression this time. He was sanctioned in connection with the 2014 invasion of Ukraine. This is one of our significant cases, but we also have charged a case to confiscate the motor vessel Amadea, which is a huge yacht valued at something more than $300 million when it was purchased. And that litigation to confiscate that yacht is pending in the Southern District of New York, in New York, with lawyers from our team and the U.S. Attorney's Office there, and the National Security Division. There are many more, but maybe that gives you a flavor for the types of cases we're doing.
Interesting. Back to Armenia. How does Justice Department plan to continue its cooperation with Armenia? Is there any other pending cases you are considering with Armenia? It's well known that United States assisting Armenia is providing very essential and important assistance in the sphere of the law enforcement to improve Armenia's law enforcement area. And I'm sure your cooperation also will be very mutually beneficial. What can you say about that?
Well, under our process, we are not permitted to talk about cases before they're charged publicly. So and that's to protect the rights of the accused in case charges are never brought. Because if charges are never brought, they don't have an opportunity to present their defense. So we take this responsibility pretty seriously. Not every country has the same rule. But because of this rule, there are a few things that we can talk about that aren't public. But I can tell you that there is lots of support for trying to share experience with our Armenian colleagues, and also, so generally, but also very specifically on allegations as we see questions to ask them about and as they see things to ask us about. And of course, we would continue to work with them in connection with any other information that we develop that might bear on the case that's continuing in Armenia related to the Khachatrans and Mr. Armstanian.
I'm sure it was productive, I mean, the cooperation. But what are the main agencies you would like to specify from Armenian side that specifically help your agency, United States government,
sure.
to
as I've
come
said,
to
the Central Authority played an important role. The General Prosecutor's Office played an important role. There were a couple of different investigative agencies who assisted us at some point in the process. I know that you in Armenia have an office that was stood up to enforce the unexplained wealth law that your country passed, and we also shared experience with them because we wanted to understand what civil non-conviction based confiscation authority they have. So it was a wide-ranging exchange. I think that there is, we hope, now that we have worked through this case together, there is a lot of hope that from what we have learned and the contacts that we have made, that there'll be even enhanced information sharing. And of course, it's in our mutual interest to be able to combat corruption and money laundering. We want to get illegal money out of our country and back to the benefit of the people harmed by the corruption, probably as much or more as the Armenian authorities would like to recover assets and hold people accountable. So we have the right shared goals, and we now have lots of face-to-face contacts. So I expect it will only grow.
And my last question will be, Wincon Elkins law firm that represents the Khachatryan family released a statement after the case was settled, and in their press release they mentioned it as a large victory for the Khachatryan family, and the case they said that it secured the successful closure of high-profile DOJ investigation and resolution of the case, and closure by DOJ of related investigation represent a significant victory for the Khachatrians and settles their long-running dispute with the Department of Justice.
Yeah, I mean, it's not uncommon in these civil cases for the claimants, after a resolution, to try to put the case in the most favorable light as possible for themselves. I remind you that they agreed to walk away from 85% of a very valuable asset. So the people can decide if that's a successful resolution for the Khachatrans, but we believe it is. And on the point about the criminal investigation, I would argue a little bit with the idea that they secured a decision. We make the decisions. And so these decisions are separate, criminal investigation versus civil confiscation. We made each decision separately, but the Department of Justice makes the decisions, and we did make that decision here. But the idea that they were able to secure it is a little bit aggressive, I think. But still, it's not uncommon for people to try to explain why they made the decisions they did. We understand that.